Since this crisis began, we've had over 30,000 people who've been denied a lawyer, and over 40,000 cases where there's been no lawyer been able to be appointed in a timely manner.
That is Washington County District Attorney Kevin Barton on Oregon's public defender crisis and the amount of cases they are or are not taking. Yesterday, we talked about some glaring flaws in Oregon's 6-year plan to fix public defense and the fact that a significant provider of public defense in the state, groups of private attorneys known as consortia, are supposed to be phased out in 2027. Today, I sat down with the district attorneys for both Multnomah and Washington counties. This month, together in Salem, they presented 6 ideas to the House Judiciary Committee, ideas they believe would provide immediate short-term relief and a long-term fix to this crisis. Here's DA Barton on one of those ideas.
What's happening right now is there is a ceiling on the amount of work that defense attorneys are allowed to do. It's called the MAC, M-A-C, Maximum Attorney Caseload. And that's a one-size-fits-all ceiling that applies across the board to everyone. And we know that there are defense attorneys that have come to us and said, we can do more work. We want to do more work. The Public Defense Commission, OPDC, they know there are defense attorneys that can and want to do more work. What we're hearing from defense attorneys is the bureaucratic hoops they have to jump through, though, to get paid to do that extra work is so cumbersome that many of them are choosing not to go through that pathway. And so if we open up this release valve and let people who can do more work, that'll be a path toward immediate relief on day one.
That's one option. Another idea is to change the law in order to allow a presiding judge to assign cases to public defenders and even private defense attorneys.
The theory is, in a crisis, everyone should grab a shovel and help out. So giving the judges the authority to say to a private defense attorney who doesn't do public defense work, hey, why don't you take 1 or 2 cases? Because if everyone took 1 or 2 extra cases, that would also help alleviate the crisis.
Just the past few weeks, I was in our arraignment courts and I was seeing individuals coming in that were there for their 2nd or 3rd case and talking about how they didn't get an attorney the previous 2 times.
So seems like an easy fix, right? The judge steps in and assigns cases to people. But this idea is already being tried down in Marion County, and it's been met with pushback from nonprofit public defenders who say it's a strategy that leads to burnout and turnover among their attorneys. We spoke with Caitlin Plummer, executive director of the nonprofit Public Defender Services of Lane County.
This wouldn't be the first time that Marion County judges were forcibly appointing public defenders who were saying that they couldn't handle any more cases. And in the aftermath of that, many public defenders in Marion County left that work because they couldn't handle the caseloads. And that simply worsened the problem. And then I think on a bigger scale, if we're talking about a solution to this problem simply being to make public defenders take more cases, that is not a solution.
We're not really focused in on those, the younger or less experienced attorneys. We're looking at how do we impact the areas where it is really affecting us day in, day out. And those are on some pretty important felony cases that are currently not getting attorneys.
I think the primary strategy that we're employing and suggesting is letting attorneys who want to do more and have the capacity and willingness to do more, taking the handcuffs off of them and letting them do more. That won't contribute to burnout. That will contribute to a solution. And I think anyone that suggests that contributes to burnout is not being honest with the facts.
The Multnomah and Washington County courthouses account for over 15,000 filed criminal cases each year and include about 45% of the state's currently unrepresented defendants, which is around 1,500 cases, which the DAs argue ultimately causes community harm.
And how it has a real impact, though, is that we also see there are individuals that will be charged with a smaller crime, and then they won't get an attorney, and then all of a sudden they'll come back on much larger crimes like murder, attempted murder, robberies. Mm-hmm. These are huge issues that are creating just devastating effects in the community.
And then there's the issue of people not showing up to court, failure to appear. They get a warrant for their arrest, and that case is stalled, if you will. It's not moving forward. And that is true for almost half of all open cases in Multnomah County, according to the DA's office. And as it stands right now, those warrant cases are still being counted toward a public defender's workload, which DA Vasquez's first assistant, Kirsten Snowden, says is a big problem.
So what happens is when there is a warrant for someone's arrest, Under the MAC, as I understand it, the public defenders are required to file a notice of withdrawal from the case if the case has been in warrant status for 6 months or longer. But we're not seeing that.
Snowden says, and without accuracy here, it could appear that public defenders have more cases on their plate than they actually do. The Oregon Public Defense Commission, or OPDC, is now talking about addressing this issue. Some argue it should have happened years ago.
One of the things in our proposal that we've talked a lot about is that there needs to be better transparency and accountability. We have been repeatedly asking for things like the case numbers, and when we do, we're often met with a lot of excuses and reasons why they can't, and it really leads to a lack of confidence and trust in the system.
We want to see the case numbers of the major defense firms overall so that we can understand why the data looks different, why they're reporting having more cases than we're showing. We need to better understand exactly what's going on in the management of these nonprofit firms to understand why they believe they are unable to take more cases. No state in the country, with the possible exception of Alaska, is paying more for indigent defense than the taxpayers of Oregon. And so if we still are paying that much money, I mean, we've literally tripled the amount of money. It went from, I think, about 300,000 or 300 million we were paying for indigent defense back in 2017 to over 600 million today. I think all of us deserve to know what we're getting for that money, and that starts with transparency and understanding the case numbers associated with the contract numbers they're reporting.
So time will tell if that comes to be anytime soon. But yesterday, we promised to talk about some of the bills before the legislature that could change the state's path on public defense. If the testimony before the House Judiciary Committee last week is any indication, it's really just one bill, which could go in radically different directions. Representative Jason Kropf, a Democrat from Bend, is the chair of the committee and a former public defender. He introduced House Bill 2614, which, as you can see here, is pretty brief, but the text of the bill here is nowhere near what this will eventually turn out to be. It's what is known as a gut and stuff bill. They'll erase all this and change it with amendments. But right now, there are 3 amendments on the table. The first would roll back changes from 2023, directing the state to consider national and regional best practices when setting public defender caseloads and compensation, changing the law to be even more vague so that the state just needs to follow the Oregon and U.S. constitutions. It would also erase text, basically saying that public defenders should be paid fairly, and it would extend the sunset on private public defense consortia to 2029. We mentioned that yesterday. The sunset is currently 2027. A second amendment proposed by Kropf would give the Oregon governor greater authority over the Oregon Public Defense Commission, removing their current independence. The third amendment would direct the Oregon State Bar to require that all trial attorneys be trained in public defense and serve at least 120 hours as a public defender before 2029. Now, many of you have proposed an idea like that, but this one got the least bit of love during that hearing. Suggestions during testimony, including from the district attorneys, might shape further amendments to this bill. There were a lot of speakers pushing for consortia to stick around indefinitely, and a few wanting the state to add flexibility for attorneys who want to take on more cases. But some public defenders worry that what's already on the table rolls back much of the positive change they pushed for back in 2023, telling public defenders, not in so many words, that the beatings will continue until morale improves. Caitlin Plummer was one of the many who testified before the House Judiciary Committee last week.
I think the message from the legislature needs to be that we support the public defense workforce, that we support them in having manageable caseloads and fair pay. And I worry that those changes might send the wrong message, even if that's not what is intended. So we can solve this crisis. We absolutely can, but we need those fair salaries and we need those reasonable work loads in order to do so. Without those 2 crucial pieces, we're not going to be able to retain the existing workforce, let alone bring new attorneys into the system that we really desperately need.
Okay, so we know we've been hitting you with some dense stories tonight on the show, but we know a lot of you care about this crisis or are even involved with it in some way. So what do you think needs to change? Do you like ideas from DAs Barton and Vasquez? And how about that bill? Email us, thestory@kgw.com, or call and leave us a voicemail, 503-226-5090.